This is David Brown. I hope you enjoy this video short, but know that this is only for informational purposes. It does not create an attorney-client relationship between you and the firm, and we recommend that you contact a licensed attorney if you have any questions or concerns about the information provided. The E-3 visa is a non-immigrant visa that is only available to people who are citizens of Australia. It's an allowance that grants someone an opportunity to work in the US for 2 years at a time, and in theory, it can be renewed indefinitely. The application is typically processed at a US consulate anywhere in the world, but we often apply for this visa type in Australia, Canada, Mexico, and some of the other European US consular locations. When we file this application, we first need to file an LCA. The E-3 operates very much like the H-1B status, and as a result, the LCA is a requirement to prove that the individual taking the position is not undercutting US workers' wages. When we file the LCA, it goes through the same LCA requirements of posting and notification to people at the worksite, and the same requirement that we review the prevailing wage and confirm that it meets requirements of USCIS. However, the nice thing about this application is since it is consular specific, once we filed the LCA and drafted all the necessary underlying materials, the individual simply fills out their DS-160, completes it, submits it to the folks at the consulate, and then attends the consular appointment. At that time, they should be granted a 2-year visa. When they come to the US and enter on that visa, they should be granted a 2-year entry to match that visa. So from the perspective of the H-1 and the L-1 and some of the other visa classifications we work with, the E-3 is typically an easier process to work through. If you're an Australian national and are recently hired in the US and need an E-3, please let us know and we'd be happy to help you.